Hi, and welcome back to Hunter UK. Now, guys, first of all, I'm going to have to say you're going to hear a lot of me talking in this video. So I'd like to apologize if this sounds boring or you fall asleep. But what I have to say, I do feel is important. I also like to make an apology to all of you if you were expecting a live stream this weekend. But unfortunately, this is just not possible. I'm not ready. But I do plan to do it next weekend. Now, about that first live stream. I thought it went well, and I'd like to thank all of you for listening and participating. I looked at the chat, and the chat was very good. Now, I thought the mods done an excellent job, so I'd like to say thank you to you mods, and I hope to see that you will be in the next live stream. So, when I finished and replayed the live stream, I thought about that video of who was in 135 before Stephen Paddock. Guys, there is missing evidence here that could either support legitimate simplistic answers, or it could support something more than what this was leading us to believe, or finally, it just could support fully the narrative. The more I thought about it, the more I thought the next live stream has got to cover the court hearing of April 2018. This then would flow straight into the missing evidence. Now, I've got a couple of guests lined up to discuss this, and if we got time, which I doubt, we will also go over the internet searches. So back to that first live stream. Now, if we all agree that the FIT report was correct in reference to the timing of the sushi, I still have those same nagging questions. From the VIP check-in desk to the elevator, we still have 45 minutes that are unaccounted for. Then we have a further 18 minutes also missing from the center court to the door of 135, where we assume that Stephen Paddock swiped the door and dropped off his laptop. So I thought, this is still bugging me. What is the missing evidence? Well, there is enough cameras at casino level to plot his route. We could cover those missing 45 minutes, and the simplistic answer may well be he was sat on a poker machine, but we just don't know. We then got Stephen Paddock entering the lift. So what is missing is, what floor did he get out of? Then, if Stephen Paddock entered 135 to dump off his laptop, then missing could be the elevator footage of around 4 p.m. Now, this is the type of evidence that I believe is missing, and this is what we need. So then I continued to think about that court hearing, and I thought it'd been a long time since I read and understood it. So I thought I needed to go back over it and read it, all of it, the transcripts and all, 279 pages. In that transcript, it clearly states that the judge had said that the LVMPD is playing a game on the release of information. The Las Vegas Review-Journal had a hard job understanding what information was out there and the amount of evidence that was being withheld by the LVMPD. And in the judge's words, they said that they do not know how big the universe is. They just asked for all the information, of which the LVMPD gave a blanket response of confidentiality. There was a lot in that hearing, and probably too much to go over in that live stream itself. So I'm contemplating releasing a video just giving a high level overview of what was said within those hearings. But what underpins the hearings all surrounds the NPRA, which is the Nevada Public Records Act. Now, I started to ask myself, what is a public record? I will go through that, but in a nutshell, the NPRA states that all agency records are public unless declared confidential by law. The ruling of confidentiality of a particular part of evidence is that of the court and not the LVMPD. Under the NPRA, information is by default public record unless specifically confidentiality restrictions apply. Now, this led me on to other thoughts about other cases, and all the evidence is handed over to the DA and to the defense team. This is then presented in a court of law, and it becomes public. Now, think about a case like O.J. Simpson. All evidence was presented in court. This then led to further faults. Let us just say that Stephen Paddock escaped, and they caught him 5 days later, and then a court case ensued. All evidence would be shared and released within court. I'm sorry, but then that led to further faults. Firstly, How convenient for the LVMPD that Stephen Paddock was dead and a court case would not ensue. The court had stated that Lombardo had stated that Stephen Paddock was a lone wolf and he was responsible, and the fact that they were not looking for anyone else, and yet still the LVMPD stated that there is an ongoing investigation. Now, the ongoing investigation was in reference to Douglas Haig at that time, so the courts placed an argument. Now, this is just the example. The releasing of the 911 calls were deemed public, and there's a slide that I will show you where they said this. But anyway, they were deemed public, and this had no association with Douglas Haig. So why had they not released the calls? Well, guys, we know that they eventually did release the 911 calls, but this is where my guest is going to come in, because I want to know how many 911 calls were identified in total number, what calls were released, and what is still outstanding. Now, an issue I have got with missing evidence is that it is all not required. So it has always been my plan to look at the evidence, what was written, and to see where there was a gap that does not support the written or verbal narrative. Now I'm going to give you another example. Stephen Schuck. Yeah, Stephen Schuck has always given me an issue for various reasons. So in the final report, it states that he was on the 62nd floor attending a leak when he received a call from Shannon Aylesbury, and then he went to the 32nd floor, whereby he met Campos. For me, the missing evidence would start off on the 62nd floor, whereby it would give us a time from the lock interrogation report as to when he left after receiving that call from Shannon Aylesbury. We then would have the elevator footage of him entering and exiting the elevator. He then went into the hallway where Campos was, and he dived into 32117 and he swiped the door. Now, if we had the lock interrogation report for 32117, it would give us the timeline of when Stephen Paddock shot down the hallway, and it would indeed prove that Schuck was there at that time. So now people's going to argue with me probably that the lock interrogation report is not public and it belongs to the MGM. And I would still argue that point, that the fact that it is public. In the final report, they have released the lock interrogation reports of both 134 and 135 for the duration of Stephen Paddock's stay, thus making that report public. Remember what the NPRA states: information is by default public record unless specific confidentiality restrictions apply. The question is, did the LVMPD request the lock interrogation reports from the MGM? Reference to the points that I've just made, I would say of course they did, because this would help them with the timeline and Schuck's statement. Secondly, the fact is that they did publish the lock interrogation report of 135 and 134. This sets a precedent. Where is the specific confidentiality restrictions in that report, and how would that apply? Because they released it. So question, why would they not release further lock interrogation reports to fully support the narrative? Once this had been handed over, it would have been public records. As I said, if Stephen Paddock would have escaped and was captured, all of this would have been requested by the DA or by the defense. Just because Stephen Paddock was dead, this, in my opinion, is irrelevant. They should still release the missing evidence in accordance with the NPRA, which promotes transparency. Now, what I'm going to do is I'm going to show you just a few points from the court's memorandum, which is a high-level overview of the 3 court proceedings. It's just be some small abstracts. Anyway, like I said, I hope to do a video and pull out even more. This will just give you the opportunity to be ready for the next live stream. So let's have a look at some of the comments. So this is a memorandum of points and authorities, and as you can see, this was filed on April the 24th of 2018. Despite the fact that almost 6 months has passed, the Las Vegas Metropolitan Department has refused to produce a single public record about the 1st of October. Metro has thwarted access to every each record the petitioners have sought, including 911 calls and body cam footage. Despite the many questions the public still have and the dogged efforts of the media to utilize the Nevada Records Act to get answers. Even after the Review Journal and the other media outlets filed suit under the NPRA, Metro still failed to produce a single record. This is at odds with the NPRA, a robust public records law heavily weighted in favor of access in order to promote transparency. Metro has also never bothered to support its ongoing withholding of every document requested by petitioners about the 1st of October. Instead, Metro has acted as if it is exempt from the NPRA. At best, Metro asserted blanket confidentiality claims. The ongoing investigation Metro previously relied on to justify withholding every 1st of October record was pertaining to a man, Douglas Haig, who sold some weapons to the shooter. It is just not possible that every withheld record relates to that investigation, let alone jeopardize it. Metro's case is a house of cards. This is from the court. While Metro casts the issue it raises as novel, the law as to the application of the NPRA is clear and does not allow Metro to withhold records or demand excessive fees before allowing access. Now, this is a lot, guys, and I'm sorry if you find this boring, but it is important because it gives you a history of it. We're still there. We're still missing all the evidence. They may well have produced webcam footage, not all of it. They have produced statements, not all of them. 911 calls, not all of them. So anyway, it says, as a status check on March the 22nd of 2018, the newly assigned judge directed Metro to supplement the motion and support withholding. Significantly, at that juncture, the district court granted a temporary stay until April the 27th. Then, rather than justify his disobedience to the NPRA, Metro abandoned the initial motion, appealed, and filed OST motion. The district court thus noted that at this juncture you are creating the emergency. Metro itself, not the court or the court orders. Even after being called to task by the district court for its dilatory behaviour, Metro has not stopped its gamesmanship. On April 10th, the district court announced its decision to deny the stay and made it clear it was dissolving the temporary stay that it had granted and specifically advised Metro of its ability to seek a stay from this court. Yet, Metro, which has stables of attorneys and more than ample resources, waited 10 days to file its emergency motion. Metro also failed to advise petitioners until the mere day before it was filed. And despite waiting 10 days, Metro's motion is rife with procedural flaws. Thus, even if the NRAP test was satisfied, which it is not, emergency relief is not warranted. Now I want to go on about the 911 calls, which I said earlier on. And this is what it said in the hearing. When individuals at the Route 91 Harvest Music Festival placed calls to 911, those calls were not part of an investigation. They were calls for assistance made by citizens. The moment those calls were made, the calls relating documentation become public records. The mere fact that the LVMPD and other law enforcement agencies are now investigating the incidents does not affect the public nature of the calls. In sum, the LVMPD has not met its heavy burden to establish that requested records are confidential, and the interest in disclosure outweigh any hypothetical claims of confidentiality. Accordingly, the 911 calls and related documentation that the LVMPD has should be produced. But we still got outstanding calls. Now I finally want to finish up by the Honourable Steffi Miley, which is in the transcript of the courts, and this is what she was actually saying. I mean, there's gamesmanship going on here. Now, this is a judge. It's not Joe Soap. This is not the attorneys. This is the judge. I mean, there's gamesmanship going on here. That's why I keep saying the urgency is created by Metro. It's not created by any decision the court making because you are getting what you are wanting. You got to delay after Scotty. You got to delay after the court set a status check, the motion for reconsideration. You got another delay until there was hearing set on the motion for reconsideration. So you could have done what you're doing now. You could have done it months ago, but all you've done is prolong the proceedings even further than it should have been. And that's what is very concerning to me. It seems like a game. Yes, it did seem like a game, and we're still here 29 months, and we still have not got all of the evidence. And we're going to talk about that in the next live stream. Anyway, well, that's about it for this video. But I just wanted to give you an insight into my plan of the next live stream. The foundation of the missing evidence lies within the court hearings. And then we ask the question, what evidence do we require to support? As I keep saying, it either supports legitimate simplistic answers, or it will support something more than what is leading us to believe, or it will support fully the narrative. But it's missing. As it stands, there are many leading questions that need to be answered. So next week, the hearing and the missing evidence with a couple of guests. Then I'm going to follow up with the start of the journey, which will be all about the internet searches. This then will lead into the Ogden. Well, guys, I want to thank you for watching, and I hope you didn't fall asleep. But I hope to see you in the next live stream. So thank you for watching, and take care.